Good morning, everyone. Welcome to the First District Court of Appeals. We have 4 cases set for argument today. And just so that I can get everything straight, I'll go through the cases and the attorneys who will be arguing each case. The first case set for argument is case number C22-0019 and 035. It's Niehaus versus Durrani. And my understanding is that Mr. Williamson will be arguing for the appellant.
Correct, Your Honor.
Okay, and Mr. Winter will be for the appellee.
Yes, Your Honor.
Okay, great. The next case up is case number C22-0020 and 036, Stevenson versus Durrani. And with this one, it will be Mr. Herzig for the appellant.
Yes, Your Honor.
And Mr. Winter for the appellee.
Yes, Your Honor.
You have a busy morning. Next case is C22-0021, Hounsell versus Durrani. And for appellant, I have Mr. Williamson.
That is correct, Your Honor.
Okay. And Mr. Winter for appellee.
Yes, Your Honor.
And the last case is C22-0022 and 039, Mann versus Durrani. And then we have Mr. Herzig for appellant.
Yes, Your Honor.
And Mr. Winter for appellee.
Yes.
Okay, great. So we'll start with the Niehaus case. And this is a cross appeal, so both sides, I think, can reserve some time. Mr. Williamson, how much time would you like to reserve?
3 minutes, Your Honor.
3 minutes. And Mr. Winter?
2 minutes, Your Honor.
2 minutes. Okay. So I'll use the lights on your podium. The yellow light will come on when you have about a minute left of your initial time.
Oh, perfect.
Okay. Whenever you're ready.
May it please the court, my name is Philip Williamson, appearing on behalf of Dr. Durrani and Center for Advanced Spine Technology. Your Honors, you have, I think as we pointed out in the brief, essentially seen this case before. Dr. Durrani did not perform the surgery on Ms. Yeagle. The surgery was actually performed by Dr. Shanti. And the facts of how this came to be, I think, are going to be important for how you evaluate the strength of plaintiff's case here. Ms. Yeagle went to the ER after a series of falls between Thanksgiving of 2012 and roughly Valentine's Day of 2013. In particular, after a particularly bad fall on February 9th, she goes to the ER complaining of leg pain. There is some dispute over what else she complained of. She reports low back pain, severe back pain, moderate back pain, sort of over the course of her stay in the hospital. The ER physician calls for Dr. Durrani to consult. Now, Ms. Yeagle will tell you today that all of the pain was localized to one knee. That's an odd claim because I don't think you call in a neurosurgeon to consult for localized knee pain. Physical therapist also identifies Ms. Yeagle has some lower leg difficulties. MRI confirms that there are some back pains and a protruding disc. That much is undisputed. And so after an evaluation, Dr. Durrani recommends Ms. Yeagle have surgery. Due to a conflict, Dr. Durrani cannot perform the surgery and asks Dr. Shanti to step in and perform it instead. All of the experts in this case agree that Dr. Shanti at that point was entirely responsible for Ms. Yeagle's care and had an independent duty to satisfy himself that surgery was warranted.
So let's distinguish this between White and Walls, where there was no recommendation by Durrani in those cases, or the recommendation was not the driver for liability. Here, there is a recommendation for surgery. I understand what you're saying, that Shanti is the one that carried it out rather than Durrani. But how do we, is there a distinction, is that distinction significant enough as plaintiffs are trying to distinguish those cases?
It's not, Your Honor, and you can look at plaintiffs' own experts on that point. Plaintiffs' own experts agree. Dr. Bloomfield testifies that when Dr. Shanti took over Ms. Yeagle's care, when he was the one who asked to step in to do the surgery, he assumed complete responsibility for her care, including the duty to decide whether that surgery was medically indicated, and if he thought it was not, he had a duty to cancel that surgery.
So that completely alleviates Dr. Durrani from any responsibility for obtaining informed consent at that point?
Correct, Your Honor.
Okay.
as we pointed out in our briefs, the tort of informed consent is a sort of negligence child of battery. It is to perform a procedure to touch a patient without receiving consent from the patient to do so. Well, who can commit that tort? The person who performs the procedure. The person who performs the surgery is responsible for ensuring they have informed consent to proceed.
But Dr. Durrani recommended it. He was supposed to perform the surgery up until the day of the surgery, and apparently Dr. Shanti was an employee of his. So how is he completely alleviated of any responsibility here?
Your Honor, I think it goes to sort of two of the core arguments that we've made on causation and duty. I'll start with duty. There's no duty to obtain informed consent to recommend a procedure. The duty is to obtain informed consent before you perform the procedure. The person responsible for obtaining informed consent is the person who is actually going to cut the patient open. The fact that Dr. Durrani made the recommendation does not make him the tortfeasor for informed consent.
Well, but what if the situation was Durrani meets with a patient on Monday and says, here's what I'm going to do. Do I have your consent? And, does all of what he's supposed to do on informed consent. And then Durrani has to go away or whatever. And Shanti then is the one to perform the surgery on Wednesday. And Shanti looks at the notes and says, oh, Durrani's already got informed consent. I don't have to do anything. What would happen in that scenario?
Well, Your Honor, if in that scenario Dr. Durrani had in fact obtained the patient's informed consent, then Dr. Shanti is fine. Informed consent has been obtained. It's not a question of who has to physically hand the piece of paper to the patient. You can have a nurse, you can have an assistant, you can have another doctor do that. The question is, who is responsible for ensuring that the patient has consented prior to putting them under and cutting them open?
Didn't he obtain, I mean, I know that is your argument that the consent was the incorrect medical procedure? I mean, he did obtain informed consent, right?
Well, Your Honor, our position at trial was that in fact Ms. Yeagle did give informed consent to the surgery.
From Durrani.
Again, Your Honor, it doesn't matter who hands the patient the piece of paper.
Okay.
The question is, who is responsible for making sure when I take the knife and cut the patient open, whose job is to make sure that informed consent has been obtained?
And forgive me because all these cases blur together as they probably do for you too, but in this case, was there evidence that Shanti got informed consent or tried to get informed consent?
Yes, Your Honor.
Okay.
One of the issues that is not disputed in this case is that there is a completed informed consent form for Ms. Yeagle. There is a dispute over whether she was capable of giving informed consent at the time. We are stuck with what I believe is an erroneous jury verdict on that question. But we have an informed consent form.
Wasn't the issue on informed consent in these cases is that the position of the plaintiff was that the procedure was not medically necessary? I mean, there was informed consent apparently by Dr. Durrani and by Dr. Shanti, right?
Right. So that one of the plaintiff's theories is that you can't give informed consent to an unnecessary medical procedure.
Right.
Which really sort of attempts to piggyback informed consent onto the earlier negligence claim, which is still a problem for plaintiffs. The core problem being there's no evidence of causation for connecting Dr. Durrani's recommendation to Ms. Yeagle's injuries. The expert testimony, again, from plaintiff's own experts, does not give you causation. It's just
why
not
not?
there.
So Durrani says, you need to go have this surgery, and she says, okay, I'm going to go have that surgery. It turns out Shanti performs it rather than Durrani, but how is that not something that starts the causal chain?
Well, Your Honor, starting the causal chain is not enough. You need proximate cause, and Ohio appellate courts, including this court, have been very clear. You need expert testimony to draw out that proximate cause chain. There are two places in Dr. Bloomfield's testimony that I would point you to. The first is where he is asked, when Dr. Shanti agrees to do the surgery, he assumes full responsibility, correct? And Dr. Bloomfield agrees. He goes on to say, Dr. Shanti had an independent duty to satisfy himself before he ever touches Ms. Yeagle that the surgery is medically indicated, and that Dr. Shanti actually performed that duty. So that's sort of the first break in the causal chain. The other is that plaintiff's counsel questioned Dr. Bloomfield for, I think it was 5 or 10 pages of the trial transcript, asking for using sort of all the magic words of medical testimony, asking for his opinion on causation. You do not find anywhere in that 10 pages of text Dr. Bloomfield testifying that Dr. Durrani's negligence proximately caused Ms. Eagle's injuries. You have questions about whether Dr. Shanti's negligence does, but you don't have that for...
Is Dr. Shanti an agent of CAST?
Well, Your Honor, there is some disagreement about whether Dr. Shanti constitutes an agent of CAST, but that question is in a large sense beside the point. First of all, because you cannot have vicarious liability assigned to sort of the hospital or to the clinic without first finding that the doctor or the provider was primarily liable. And we don't have that here because plaintiffs decided not to sue Dr. Shanti. This is a problem that the court identified and addressed in both Walls and White.
But what do we do, like what you were saying about Bloomfield's testimony, but what do we do with the jury finding that 100% liability on Durrani and 0 on Shanti?
Your Honor, what you do is you throw that jury finding out because there's no evidence to support that jury finding. I mean, it's not just that the jury can sort of render whatever verdict it wants and we live with it. There has to be at least something in the record that would allow the jury to reach that decision, and it's not there. And Your Honor, I have to point out, we go over this at length in our opening brief, and there is no response to that argument from the plaintiff's side.
Can I back up and just try to understand, because it was an answer to one of Judge Bergeron's questions, but if, I thought you said that if Dr. Durrani had obtained, or you're saying he did obtain informed consent, then on Monday, and then on Wednesday, Dr. Shanti performs the procedure after this patient was recommended to have the procedure by Durrani, and he informs the patient of all the risks. Shanti then does not get informed consent. Are you saying that that's okay because informed consent was obtained earlier?
Correct, Your Honor.
So Shanti wouldn't have to get informed consent. It all would go back to Durrani's informed consent.
Your Honor, the duty is that before he can touch the patient, Dr. Shanti must be sure that the patient has consented to the procedure. He can execute that duty in a variety of ways. He can have a nurse go and give the patient the informed consent form. He can ask another doctor to handle informed consent. He can even ask the hospital secretary to walk through the informed consent form, as long as informed consent is obtained. The issue is that if informed consent is not obtained, who is responsible, who bears the liability? And it's the physician who performs the procedure who bears the liability if informed consent is not obtained. So Dr. Shanti is entitled to rely on Dr. Durrani, seems to have gone over the informed consent form with this patient, so I don't have to. But if it turns out he's wrong, if it turns out Dr. Durrani didn't go over the informed consent patient, it is Shanti who is responsible because Shanti is the one who has to know there's informed consent before he cuts the patient open. Your Honor, if I may, briefly on a couple of damages questions. First, on past medical damages, everyone seemed to agree, even a year and a half after the trial in this case, that Ms. Eagle did not have standing for past medical damages. And there's simply no authority for a plaintiff going to trial over objection without standing and then being allowed to retroactively fix standing 2 years later.
Did she not have some out-of-pocket expenses in this case?
Not in this case, Your Honor.
Not in this case.
No, it is undisputed that the insurer paid all of Ms. Eagle's medical bills.
Undisputed.
Undisputed.
Okay.
Listen, you even have the trial court finding in the post-trial order that the insurance companies are actually the real party in interest to the past medical damages.
Were the insurers even put on notice in this case?
Your Honor, I am not sure, but it's not the defendant's responsibility to do that. It's plaintiff's job to establish that the plaintiff has standing.
So we have no record of really anything with regard to the insurers here.
So we do have Ms. Eagle's purported attempt to join or notify the insurers before trial, clearly aware that, as we raised in our answer, day one of this case, that she lacked standing. We have the fact that the issue was raised repeatedly at trial and in post-trial motions. with Ms. Eagle sort of continuing to tell the court, we're going to take care of this, we will get this done later, eventually we are going to have the insurers joined or get standing. And as the can sort of continues to get kicked down the road, the problem doesn't get resolved until 2 years post-trial. And if I may, one comment on prejudgment interest, because I think it's important in this case, assuming you don't enter a judgment for Dr. Durrani, but you should. The trial court in this case does not even evaluate one of the mandatory statutory factors for awarding prejudgment interest, which is finding that the plaintiff did not fail to make a good faith offer to settle. The trial court does not discuss that factor at all. To misapply the standard of law, as the trial court did, is itself an abuse of discretion. So for these reasons, we urge the court to reverse the judgment below and remand with instructions to enter a judgment in favor of Dr. Durrani and Cast.
Okay, thank you. Mr. Winter?
Good morning, judges. Bob Winter on behalf of Ms. Niehaus as executor of the estate of Veronica Yeagle. I wanted to tackle the walls white because I remember those cases very well. And those cases were a situation where, as Mr. Williamson pointed out, Durrani had nothing to do with that. That was a tough argument to take before your honors. But this one's different because in White, in White, Durrani neither wielded the surgical knife nor recommended the operation was actually performed. That's how I lost, big time. In this case, Ms. Yeagle was Dr. Durrani's patient. It wasn't Dr. Shawnee's patient. Dr. Durrani recommended to Ms. Yeagle the surgery. It turned out to be non-indicated, and he worked for Cass, so did Dr. Shawnee. It's just that Dr. Durrani was the boss. He was the shareholder.
But I don't understand how that matters because, I mean, we're not dealing with like someone working at a convenience store who has to follow orders of the boss. And we're dealing with a licensed physician who has independent duties and ethical obligations. So if Durrani says, go do something crazy, the licensed doctor should say no and should not perform a surgery unless it's appropriate under the circumstance. So how does Shanti's actions and the exercise of his independent medical judgment not break the causal chain here?
Well, two things. First, it is not an independent act here under the cases that we've cited.
I mean, it has to be an independent act by Shanti. Like, he comes into surgery, reviews whatever the files are, understands what the situation is, and decides to perform the surgery. So, I mean, he is exercising his independent medical judgment and performing that procedure. How is that not independent?
He discusses his relationship with Dr. Durrani in his deposition testimony, and he explains it was just a matter of moments where Dr. Durrani said, I had it, you got it. And
Well, he should have said no then, right?
I'm sorry?
He should have said, I can't do this yet until I've evaluated whether or not it's appropriate.
Well, he performed the surgery well. No one complains about his surgery. The negligence that the jury found dealt with the planning and organizing.
Wait. You're saying no one's complaining about the surgery?
No, the actual mechanics of doing it. I mean,
They're saying it shouldn't have been done at all.
it shouldn't have been done at all. That's right. And the jury so found it interrogatory number 2. The negligence was the rush to surgery, the overstatement of the need, and she wasn't a good candidate for surgery due to her health. Those are not Dr. Shawnee type matters of negligence.
Is that how you
Those are
explain
Dr.
it?
Durrani's, and thus consequently,
The 100% to.
100% to Durrani and 0 to Shawnee. That's right. That's exactly, that's how it plays out.
I guess I'm struggling with this. Like, if you say, like, he did a great job performing the surgery, but the surgery was not medically necessary, then the surgery still is what injures the patient, is it not?
That's right, and Dr. Rohmiller had to come in and,
So even if he performs the surgery, like, in exemplary fashion,
yes,
he has still injured the patient, under your theory.
Because he shouldn't
the
have performed
injury
it.
occurred by the planning and organizing the surgery. And whether Durrani did it or Shawnee did it under the cast umbrella, it was done. And, Cass shouldn't be able to erect a nifty trick of moving their surgeons in and out, erect a independent causation.
So under your theory, it doesn't matter who performed the surgery. In fact, Durrani himself could have performed the surgery, and he would still be liable under the same jury verdict. Am I understanding
That's
you
right.
correctly?
That's exactly right, because it was the planning, organizing, it just, whoever carried it out. Well, fortunately, Shawnee did it the best he could. He did it, and the jury did not find any problem with what Shawnee did, other than do the surgery.
But he did the surgery.
He did the surgery, that's right. And the boss came in and said, do the surgery. He had a moment's.
I thought,
minimal-
didn't he delay it for a couple of days?
I think not.
Okay, maybe I'm
I
confusing this.
think no. No, it was same morning, Judge.
So Shanti got informed consent as well, the day of,
There was an attempt to get it,
an attempt.
yes.
And then she was is this the one where she was under anesthesia at the
Well,
time?
she had, I mean, it's hard to get those informed consents when you don't know what you're doing. She had drugs, yes, anesthesia.
Okay.
Why was
That's what
it,
We cited that in our brief as to what Ms. Yeakel testified to as her ability to,
Remember.
yeah,
why was a jury instruction not required under these circumstances?
because they got, the judge saw that there wasn't a need for independent causation instruction. And what came out of that dialogue between defense counsel and my predecessor is the apportionment instruction. How much of the culpability goes to Shawnee, how much goes to Durrani. And that's how that came out. And I've got it in that pile of paper over there, if you'd like me to cite to it. It's in the brief where I put it. But that's, we do not believe, and we've cited sufficient authority to show that there isn't an independent line of liability here. This is not a white, excuse me, not a white or Walls situation. Durrani was the guy, and the jury found that the negligence was caused by those activities of Dr. Durrani. Any questions along that line? Have I answered the questions? There's some discussion about past medicals. The jury returned a $400K verdict for past medicals. Approximately $285,000 belonged to Ms. Yeagle, who retains that amount. Anthem and Medicare asserted liens.
Counsel, what do we know on the record about the status of the insurers, the subrogation claims, what was paid out to them, what they settled with your clients? What do we actually know?
What we know is that Medicare had a global settlement with the Durrani folks, and all of those liens were satisfied. And the money that came for past medicals went to the Durrani victims, in this case, Ms. Niehaus. We have an Anthem situation where Anthem still asserts a lien of about 19,000 is what's asserted, and that belongs to.
Well, so do you agree with Mr. Williamson's comment that there was no dispute that she did not pay anything out of pocket for her medical expenses?
I'm not positive, but for the sake of discussion, sure, but that isn't what the standard is. It's either what you paid out of pocket or what you invoiced. And the jury found.
So she owed money?
I'm sorry?
She still owed money?
Well, they haven't paid yet.
Okay.
If
But like
that's
not,
the question.
but the insurers hadn't paid all of her medical expenses. Like there was money that she either paid out of pocket or owed?
In this case, with respect to not Anthem,
Aetna.
Medicare, there was
Oh.
a settlement. Money was paid back to Medicare, or a claim was released against Medicare.
So Medicare essentially released its entitlement to any sort of damages that would have been recovered in these cases?
Yes, sir.
Okay.
Yes, sir.
With this case, there's Aetna money that's being held in escrow, I guess?
Yes, ma'am.
Okay. How is that okay to do that? I mean, what gives the judge the power to hold that money in escrow?
That money, that claim was severed under Civil Rule 21. It's held in escrow, and this case was appealed. That's the main issue that you all issued an order on. It applies here, too.
But Aetna's never been joined as a party, right?
Not yet, no.
Okay.
Not
So
yet.
how does the judge hold this money in escrow then?
As soon as Dr. Durrani's insurance company decides to pay the judgment, the money goes into the registry of the circuit court of common pleas. Yes.
Okay. How's he have, I mean, what authority does he have to hold? I mean, Aetna's not a party.
Not yet,
Okay.
not yet.
Have they been notified?
I believe that answer is yes. I wasn't privy to those communications, Judge Kingsley, but they have been notified, and I'm not sure where we stand on formally getting them into the case. That's what we have. I only got a minute. Short version is on my cross claim. The court granted a set-off in favor of the appellants arising from the settlement that the estate had, or Ms. Yeakel had, with in UC and Westchester Hospital. That was called at $89,000 and change. They're not entitled to it under this court's decision in Adams, because the jury found for negligence and informed consents and intentional tort, and that was brought up recently in the Mackenzie Bender case, and I cited not only Adams, but a case called Johnson versus somebody or other that said that informed consent is a tort. So under Adams, you cannot give the set-off. And in all fairness to the court, the judge didn't have the Adams decision at the time. You'll see later on as we do these cases that he rules on the set-off issue in our favor based on Adams. So I'd ask that the court affirm in total, the judgment of the Hamilton County Court of Common Pleas, except for the set-off, that be reversed. Thank you for your time.
Thank you. Mr. Williamson, you have 3 minutes.
Thank you, Your Honors. I'll attempt to move quickly here. First is the difficulty of plaintiffs trying to distinguish this case from Walls and White. You will notice from the briefing, there was no deposition of Dr. Shanti taken in this case. Instead, plaintiffs submitted the depositions of Dr. Shanti from Walls and White. They certainly thought the case was close enough. Mr. Winter represented to you that Ms. Yeakel was not Dr. Shanti's patient. Dr. Bloomfield testified exactly the opposite. You won't find that argument that Yeakel wasn't Shanti's patient in the trial evidence below. I have to point out, Your Honor, it's a dangerous game to decide that you are going to let the treating physician off the hook completely, especially if, as Judge Bergeron, you pointed out, you think the injury itself was the surgery, like being cut open, because a different physician merely recommended the procedure. And I have to quibble with Mr. Winter. The injury that plaintiffs allege here was not the planning and organization of the surgery. The injury, as Judge Bergeron rightly pointed out, was the surgery. The planning, as far as I know, did not open anyone's back.
Counsel, to your point, if all that had happened was Dr. Durrani recommended this surgery, obtained informed consent, moved forward to the day of the surgery, and then hard stop, no surgery occurs, would we be here?
I don't believe so, Your Honor. The injury is the performance of the surgery. And surely the physician who actually performed the surgery is responsible for at least some of that.
But you say at least some of that. So they're both responsible, right?
Your Honor, our position is that the physician who performed the surgery is
the only one
responsible.
Okay.
But I would be a bad appellate lawyer if I did not have a plan B.
The problem here is that we really can't tell because the jury was not given an instruction to enable them to really decide.
Well, the problem here is the jury was not given evidence that would have allowed them to return a verdict for Dr. Durrani. It's only a secondary problem is that the jury was not given an instruction that accurately stated the law, that tracked the facts of this case, and may very well have made a difference in the outcome. And so it was a reversible error not to give that instruction. One other quibble on this point. It was not a matter of moments between Dr. Durrani asking Dr. Shanti to perform the surgery and the performance of the surgery. If you look at Dr. Bloomfield's testimony on pages 375 and 382 through 383 of the transcript, it's 3 days. On February 13th, Dr. Shanti is asked to swab in and perform the surgery. 13th, 14th, 15th, Ms. Yeakel is in the care of Dr. Shanti. On the 15th, the surgery is performed.
And was that my recollection? Was it right that he asked for a little bit more time or something?
That is correct, Your Honor. On the past medical damages issue, Mr. Winter told you a lot of information about a global settlement between some of the insurance companies and some of the plaintiffs. Respectfully, Your Honors, this comes as news to defense counsel. You will not find this in the record. You certainly will not find it in the record as of the day that this trial started, which is the point at which Ms. Yeakel needed to have established standing for those past medical damages. And the real party and interest question is not about the delta between the amount actually paid and, the sticker price on the bill. The real party and interest question is who paid the bill? And this bill was paid in its entirety by the insurance companies.
Counsel, I hear you on this point, but what do we do with Robinson?
Well, Your Honor, I think you ignore Robinson in favor of the clear language from the Ohio Supreme Court that if the insurer pays the entirety of the bill, which is what we have here, then the plaintiff does not have standing to pursue damages based on those bills.
What if I know you're saying that they paid everything, but in a situation where the insurer paid some, but then there were still outstanding bills that the plaintiff owed, or the plaintiff had paid like deductibles or co-pays out of pocket, in that situation, would she be able to sue for all of it? Would she have standing to sue for everything?
Unfortunately, Your Honor, yes.
Okay.
If the plaintiff does in fact have some out-of-pocket medical expenses, then they can.
Then they
pursue
can
past
sue
medical
for
damages.
everything.
But you will see in the cases where we have made this argument, these are cases where the insurance companies are paying the entirety of
Everything.
the bill.
Okay.
And you heard from Mr. Winter, we're here on appeal with insurers still not joined. We are on appeal with the plaintiff who does not have standing for past medical damages.
And am I right, the Aetna money was put in escrow, but Aetna's not a party?
Correct, Your Honor. And you asked the same question that we have been asking from the beginning of this case, which is, where is the trial court's authority to award past medical damages to a plaintiff who does not have standing, and then just hold the money, hoping that someone shows up to claim it? There's no authority, no evidence, no explanation given for that procedure below. One final note on the set-off question. Adams does not apply here because, among other things, there's no intentional tort liability, which was the key issue in Adams, was if you have a mixed verdict based on intentional and unintentional torts, and the court cannot distinguish sort of which dollar figure goes where, then there's no set-off.
Well,
This
that's
case,
because you're arguing informed consent is not an intentional tort.
in part, Your Honor, yes.
Okay.
Also highlight this piece of the argument is, of course, moot if you sustain either of our first two assignments of error.
Great.
There's no further questions. Thank you, Your Honors.
Thank you. All right, thank you both.
Mr. Winter had 2 months.
I'm sorry, I forgot, you have 2-minute rebuttal, cross appeal. Mr. Winter, if you had reserved. Judge Bergeron reminded me.
I think the only thing I'll need to address is the Robinson issue. There's a case further on that says that, what the plaintiff gets is either what the bill was or what was paid. One of those two, the greater of the two. We had the greater of the two in this case.
Well, I mean, I guess that's what I struggle with, because in medical bills, I mean, like, they're all over the map, right? And they have these crazy charges that no one actually pays. And usually that's because insurance or Medicare is a lower negotiated rate. So what did the jury award the damages on? Was it like the sticker price, or was it what was actually paid?
About $400K, I believe, is based on the bills.
Okay.
That's what I have. I just wanted to also correct myself. There was a period of time, I don't want to say that Dr. Durrani came in that morning and said, I had her, you got her, Dr. Shawnee. There was more time than that, and that is correct. I want to make sure that our position is known on that. Thank you.
Thank you. All right, thank you both for your arguments on this case. The case is now submitted. Next up is the Stevenson versus Durrani case. Mr. Herzog, how much time would you like to reserve for rebuttal?
3 minutes, Your Honor, thank you.
3 minutes. And Mr. Winter, do you want to reserve time as a cross appeal? 2 minutes, are we doing the same? Okay. Can do.
Good morning, Your Honors. Aaron Herzig for appellants. May it please the court, I'd actually like to start with a question that Judge Kinsley ended the last argument with, which is, even if the surgery had never been performed, would we be here? I'm not so sure that the answer to that is no, because you've now heard 5 appeals of trial cases in Durrani cases. In 3 of them, Dr. Durrani did not perform the surgery, and yet juries found against Dr. Durrani. Why? Because of the shortcuts at the trial court and the unfair prejudice that is replete through all of these cases. You're now about to hear 8 more cases over today and tomorrow, which have a myriad of evidentiary errors that this court has already found to be errors and only excused because they were either harmless or potentially waived. That continues. There are hundreds of trials to come. We think it's very important for the court to set rules now, reminding the trial court that whether a defendant is subject to public opprobrium or not, the most important thing about our judicial system is that it ensures a fair trial, no matter what. No matter what
We thought we'd already done that.
the allegation is. And yet, Your Honor, here, as we stand, I guess I'd be, what, you mean you've done that
never mind.
in that some sense you have ruled, but then found that the error was.
Well, no, I think that we've set in our prior precedent, we've ruled sometimes for you, sometimes for Mr. Winter, but we've tried to set that there does need to be a level playing field, and I appreciate that that's what some of your argument goes to, and maybe if I could steer you towards the collage issue first, which is an issue that we're trying to get our arms around, not only because of the content in the collage, but trying to figure out what the collage is, because as I know we've reached out to you all to try to get that, because we have transcripts, but we're not sure that those are accurate based on comments by the trial court in some of these cases where it said, oh, some of this needs to be taken out. So like sitting here today, we don't know what was played to the jury, so it makes it very difficult for us to evaluate the prejudicial impact.
I'm sorry to interrupt, but just to let you know that the collage video, which was played to the jury, has not been filed in most of these cases as part of the record. Neither has the transcript of it. But it seems like the video that we do have does not mirror the transcript. It's cut short. So just to let you know that.
There are also 2 transcripts. It appears that one is of an edited version and one is a lengthier transcript. We have observed that, at least in some of these cases, there was an order by the trial court judge to the plaintiffs compelling them to file 3 things: a transcript of the original unedited video, a transcript of the edited video, and the video that was played. And from our observation, it looks like none of those things were actually filed in any of the trial court cases. Some of the pieces of that appear to have been filed in some of the appeals here. But from where we sit, it's very difficult for us to assess exactly what was shown to the jury in any of these cases.
Thank you all. It's obviously a concern for us too. You're right. We have made motions to enlarge the record, which you have granted, and we have made efforts to try to get the record right. We are still working on those ourselves, and yes, we need plaintiffs' help from time to time, and we work with what we can. What I think you'll find in the briefing, though, is a general recognition of what of the broad context of what is there. For instance, and remember, this is introduced by the plaintiffs. It is apparently for the purposes of impeachment of somebody who is not testifying, which is not what impeachment is about. And then it does 3 things. It talks
Well,
about,
I thought they were introducing it to basically as his testimony. So they're basically calling him on cross-examination, and here's the video. Am I wrong on that?
well, none in Mr. Stevenson's case, and I believe all of the 8 cases that you will hear from here on out, there is no testimony about that particular surgery. There is no testimony about that particular treatment. I think that's the pretext under which it is presented, but it's actually presented to make sure that a jury knows that Dr. Durrani's license was eventually revoked long after these surgeries and for unrelated reasons. They use it to let the jury know that he has that he had been accused of domestic violence, merely an accusation that was never substantiated, and there was never any criminal.
And that's not in the video that we saw,
Okay.
just to let you know. So I don't know if that went to the jury or not.
Well, in the video we have, I believe, is 50 minutes, and the transcripts refer to an hour and 20-minute video. So there's a missing 30 minutes there, at least as we understand what happened.
We have a Nixon problem. One might say. No, it's an issue that we're working on. But again, I don't think there's a dispute about the general categories, which this court has said are in fact unfairly prejudicial and should not be admitted into these cases. It said it in appeals that were decided after these trials. When it then went on to say in Setters as well, it was harmless or they were waived. We don't think there's a strong argument for waiver or harmless error in the cases that you have, because in fact, what the trials become about, what is repeated throughout these trials, is license revocation, the fact that he is no longer in the country. All of those things that this court has said are unfairly prejudicial and should not come in these cases, and I think eventually you can see that they are not harmless when you look at the sizes of the verdicts. And this is why the facts matter. Here, Mr. Stevenson has had terrible back pain his entire life. He admits that, in fact, he was satisfied with Dr. Durrani's surgery. He had had pain at a 10 out of 10. Dr. Durrani made it better. He certainly didn't make it worse. And yet, we end up with jury verdicts where, in the case you just heard, he didn't even touch the patient or do the surgery, but where he does, he and in fact improves the condition, is found to be liable. But what's important about Stevenson and several of the other cases is that you're going to have to remand them under Setters 2, under the second Setters case, where you said that we are entitled to discovery of what the set-off can and should be based on the other settlements. These cases, we were never given that discovery. They proceeded to appeal. No one ever asked for a stay and remand in order to have that information. So in the first instance, this case goes back under the rule of Setters 2 so that we can
specifically, what do you say the trial court has to do? Because I think there was one of the cases where the trial court, I believe, had the settlement agreement in front of him and was reviewing it essentially in camera. So does that satisfy what you believe our rule in Setters 2 is?
No, Your Honor, and I believe that was the case when Setters 2 got here. The trial court.
That was not, I don't think so.
Okay, well,
I thought the plaintiffs just told the trial court what the settlement was, and the trial court didn't have the actual settlement agreement in Setters 2. I thought that was the distinction.
Well, so I still don't think that's sufficient, and in fact, my recollection is that what you ordered was that we are entitled to discovery on that because we have the right, and if I'm incorrect in my recollection of Setters 2, it wouldn't be enough. We have the right to test what the trial court sees there. In fact, he has been unclear about it. The procedure that they've moved to, which we have lived with, is that there's essentially a special master who is helping distribute settlements. And
Counsel, I think what your opponent's argument will be is that many of these settlement agreements are somewhat global and contain confidential information from other cases or parties. Would it be sufficient for there to be an in-camera review followed by redaction or some limited disclosure to the defense that was specific to the case being tried?
I think, yes. I recall being asked that in Setters 2 and talking about those possibilities, which is why my recollection may be different. But there are scenarios where you could protect certain information but still allow us to understand what a particular plaintiff received in those global settlements from a variety of people. The challenge is that we still don't have that discovery in this case. We don't even have the minimum that you asked in Setters 2. We don't know, for instance, in a global settlement, how they apportion the various settlements. We don't know if there was more to people that have gone to trial and less for people who have not. We have no idea how those global settlements were chopped up.
How would that impact your set-off argument?
Because each set-off is based on what a particular plaintiff would have received in their particular case. And so which is not unusual, you might see in a multi-district litigation in federal court, you might see in a global settlement, and you see it in class actions too, right? The plaintiff's representative gets more money, things like that. You get the folks that have gone through trial get the full amount maybe of what they one at trial and others get less, or maybe they triaged the cases in different ways and said there were different injuries for this person or that person and made judgments. What we've settled on, is my understanding so far, is that the special master who is helping oversee the settlements provides an affidavit saying what a particular plaintiff received. And that hasn't been tested yet, and I don't know that we will. It at least gives us some third-party confidence outside of just the plaintiff's word, and even the judge's
Yeah, that's
review.
that's where I'm getting confused. Like, I thought that Setters was a situation where the plaintiffs just said to the judge, here's the amount, and the judge didn't have anything to confirm it. In a situation where the judge would actually have the settlement agreement, are you saying that we can't trust this judge and that we need some sort of check on this judge?
Well, so two things. One, I don't think the court can tell from the settlement agreement what a particular plaintiff got, number one. Number two, trust, of course, but verify. That's our whole system, is we allow the defendants to test the evidence upon which a judge ultimately makes a decision.
But is it
And-
particularly because in this case it's so complex as far as the settlement's concerned? It's not like some simple settlement that the judge could just look at the settlement agreement and say, yeah, this is the amount?
I don't know, Your Honor, because I've never seen it. I don't think it is simple. But even if it were, again, I think our system is trust but verify. We are allowed to test the evidence upon which the trier of fact, whether judge or jury, who we of course trust, we're still allowed to trust but verify. And it's
Counsel,
that verification piece that's important.
can you help me understand, is it just that you're trying to get to the accurate number for this particular plaintiff? And examining whatever evidence has been presented to the judge in camera of the settlement will help you do that? Or is there something more that you're looking for?
No, Your Honor, we want to know the correct amount that a particular plaintiff got, so we understand the particular set-off in the particular case. We are not, and this is all outside of the record, but we have offered solutions that would protect confidentiality of certain information, or that would protect certain.
What do we do with
pieces
the
of-
intentional torts here, though?
So I think wherever you have, first of all, we would disagree still with Adams that if they're mixed, you automatically assume that everything is intentional. But understanding that that's the rule of this court, we would what we need is apportionment of that. We think fairly across the set-off. We don't think all of these not all. Some of these verdicts include both intentional and unintentional. When we ask for an apportionment instruction, it should be given. In fact, we shouldn't have to ask for it anymore. The court, knowing that the set-off issue is there, should make sure that we understand what the jury is awarding for negligence and for intentional torts, and then you would set off for the negligence piece of that. That's the rule we think that the court should apply. I know I'm well beyond my time, and I'm sure there'll be a chance to address these other questions.
Thank you so much.
We've got plenty of time over the next 2 days, so.
We have so much time.
Bob Byrne on behalf of Patrick Stevenson, the appellee. Let's talk collage, if I may. That seems to be an issue. I read the transcript. I looked at what was sent over to you on the link. I mean, it seems like a lot of questions were asked of Dr. Durrani as if on direct. You know, tell us your name, where'd you go to school, where were you born, what did you, where do you practice? Tell me a little bit about your medical habits in terms of looking at MRIs. Do you interface with radiologists?
But after that, it devolved pretty quickly into you inflated your resume, you had your medical license revoked, you were, all of these things that aren't related to the case and seem to be pretty, other bad acts that he's being accused of here.
First thing, I think at least 2 trial judges, maybe 3, have gone over the initial thing. A lot of the things that we believe were relevant were excluded under 403. Now, getting to your point, Judge, a man states under oath, have you, that he was asked under oath, do you have any medical malpractice cases pending? He says, I don't know. I had a third party fill this out, and then I signed it under oath.
What was the point of asking those questions?
I'm sorry, Your Honor.
What was the point of I mean, there was a time where the lawyer went through every malpractice case that had been pending and named the case, and Dr. Durrani said, I don't remember, I don't know. What was the reason for doing that
Because the man lied under oath.
on his application?
Yes.
How do we know that?
Excuse me.
How do we know that? Where is the proof of that? So I see in this collage that plaintiff's counsel is asking a lot of questions of Dr. Durrani about things on his resume and things about his license and other cases that have occurred where he's been sued for medical malpractice and other things. How do we know that any of these questions are factually true? I don't see in the record, for example, his CV or his resume containing these assertions that he's made. I don't see in the record this MedCloud bio that supposedly has fictitious accolades about Dr. Durrani. I don't see in the record these other medical malpractice lawsuits that were supposedly filed against him. And I don't think that plaintiff's counsel were making them up, but I don't have any way to verify that they're true.
Well, I think that they were not allowed in because they're collateral matters. So we're not going to have a trial on whether Dr. Durrani had a medical malpractice claim pending at the time he re-upped his
So
Ohio.
if that's a collateral matter, then how is his answer not also a collateral matter?
Because he made a statement under oath, and the jury was allowed to see what he said under oath and how he said it.
But he didn't admit to the medical malpractice case. He said he didn't remember. He didn't know.
Oh, he said, oh, shucks, I had a third party fill this puppy in, and I just went ahead and signed it. That's what he
Right.
said. And
Right, but when he was specifically asked about leaving off medical malpractice cases off of his application, he said he didn't know. And so then the lawyer just starts spouting out all these medical malpractice cases, but never gets Dr. Durrani to admit that they in fact were pending. So how is that evidence, the lawyer's question?
well, you can't, we were not allowed to show him, here's the document, and here's the malpractice claim. And
Why not? You weren't allowed to show him and impeaching him the documents?
that type of thing was kept out, as I understand it. I wasn't there to do that, Your Honor, but a lot of things that we believe should have been asked of Dr. Durrani were edited out. And the point to all this is that the only way that there are two ways that Dr. Durrani can testify to this jury. One is on the collage, second of all, on the medical records that he created. And we believe, again, that the medical records that he created are a sham and false. And Dr. Bloomfield and Dr. Sayani made that clear. He fudged the imaging, he fudged
So, counsel, I understand that that's your allegation, but can you help me understand how some of the testimony in the collage advances your theory of falsification? So, for example, Dr. Durrani is asked about his claim on his CV that he holds 4 patents. It appears that plaintiffs believe that's untrue. And Dr. Durrani says in response to those questions that it's true. He says again and again, you claim to hold this patent, that is true. You claim to hold that patent, that is true. So how do his answers verifying the truth of his CV advance your theory that he falsified records?
because other questions are asked. Have you, when you re-upped your application did you have a criminal matter pending, yes or no?
That doesn't answer my question.
I'm sorry.
I'm talking about the patent specifically. Let's focus on that one, because there's a lot of statements in the collage, and we need to take them question by question. So let's focus on the patent series, for example. How does it advance the idea that Dr. Durrani falsified the medical records in this case to tell the jury that he says it's true that he holds 4 patents on his CV?
He made a truthful statement under oath.
And what does that do in terms of evidentiary value?
It does not advance our concept and our principle that he is not unable to make a false statement under oath. He can sometimes make truthful statements, he can sometimes make false statements.
Okay, so it gives the jury a counterpoint?
Yep. Yes,
Okay.
ma'am.
All right, thank you.
Yes. And we've made that point. Yeah, the medical records are what matters. You know, he's chosen not to show up at trial. The only way he gets to testify is through his medical records. He has 2.
Yes, so you've got the medical records, and you've got your experts who say these medical records, you know,
Yeah,
he's
yes,
he's cut corners, he's fudged it, whatever they say.
Right. And
So,
he's done it in the past.
and he's right, and
Under
so, but what is the need for the collage at that point?
He has a long stand. I mean, all these events are somewhat not in 2015.
What you were just about to say, I think, is his longstanding practice of doing bad stuff, which is.
I mean, it's under, I mean, he made statements under oath.
But the problem is, like, I mean, you can't find him liable because he's a bad guy, like, and because he's done stuff in the past. Like, it has to be, what did he do to this particular patient that was outside the standard of care? And for that, you've got the medical records, you've got your experts. And my concern is, like, does this collage unfairly tip the scales in a direction that shouldn't be under the evidentiary rules?
And I most respectfully suggest that it doesn't. He makes statements under oath, and then treats patients and fudges medical records not only to the hospital, but to the primary care physician.
I think part of the problem, though, is when you look at the way the questioning goes, for example, he's asked about the blank prescriptions that he signed when he went to Pakistan. And then he's asked about, okay, in March 12, 2014, your medical license was permanently revoked. In April, your Kentucky license was revoked. But there's no connection between, like, there's no reason why. There's no connection between the blank scripts. So it's just, these questions are just being thrown at him without any connection that would go to lying under oath. That's what you're trying to say, is that he didn't put, I mean, I'm trying to understand, like, what the connection is and the way these questions were asked. You know what I mean?
Yeah, I think we have the setter's decision that relevancy, the other evidentiary issues, but it's still harmless error.
Okay, so you're saying it's error, this was error, but it's harmless error.
I think the court's already addressed that.
Okay, and so why for example, in this particular case, Stevenson, is it harmless? If you're saying that the collage is error, why is it harmless?
I'm just saying that portion of
That
the
portion
law,
is error.
that small portion dealing with, yes, with that.
With the license revocation.
That's water under the bridge.
What about the listing of the malpractice cases, one by one, where the lawyer goes on and says, you were sued by this person, you were sued by this person? Is that error?
No.
Right, why not?
Because he was asked under oath, have you been sued for medical malpractice?
Yeah, but you can't just ask that question. It has to be in relation to credibility, right?
credibility under oath. He has no qualms about making a false statement under oath. That's what we showed.
But he didn't, he was never impeached with that information. It was simply a question by the attorney, and he said, I don't know.
And it was kept out. That's right.
Okay.
How do we know that it was kept out? Where is that in our record?
I don't think that ever, I don't know if that,
Were these materials proffered somewhere so that we could review them?
the judge reviewed, Judge Sunderman reviewed this twice. I believe Judge, the former Hamilton County Circuit
Swigert?
Court of Common, yes, that's right.
Well, I mean, this gets back to the question we started with Mr. Herzig about, like,
Yes, sir.
we need both of your collective help in getting us the actual collage that was played to the jury so that we can evaluate that. And right now, we've got a couple of transcripts that we're not sure are complete or not, and we have one version of a collage that seems to be a half hour short of what the representation was at trial.
Yeah,
So we would encourage both of you to work together.
I saw that was a little short when I saw it.
Right, well, and it matters because, like, if
Yes.
stuff was cut out, like, we want to know, what actually was played to the jury.
My recollection is that the collage transcript was filed on the record, and while Mr. Herzig was discussing the matter with you, I was trying to leaf through and I couldn't find the thing. But I will get with appellant's counsel and address that.
You are at your time if you want to reserve 2 minutes.
Let me just dive
Just keep
in.
going? Okay.
Let me just keep going. Let's do the set-off. Unlike the previous case that had only informed consent, which is an intentional tort, this one had battery, fraudulent misrepresentation. The judge didn't have the benefit of Adams, and he gave appellants a set-off of $87,400-ish.
Counsel, let me ask you this.
Yes, ma'am.
I think we're in a little bit of a chicken and egg situation with the defense claim for due process and the right to inspect these settlements, and then your argument that these are blended torts, and so set-off is not going to be granted anyway. Which issue should we consider first?
Well, you should have considered whether they should get the documents in the first place. They're not entitled to due process because Adams and that Johnson case say that, and others say that intentional tortfeasors do not get a set-off, period. So it could be $1 million, it could be $0, well, $5. They don't get to see what's there because they're not, it's a big so what. They don't get that. Now, in cases where, excuse me, Dr. Durrani and Cass are only liable for negligence, they got something to talk about.
What would be the source of information in knowing that the settlement encompassed both intentional and unintentional torts? Is that the complaint or is it the settlement document? I mean, in theory, you could sue them for both and they could settle on only one type of tort. So how do we know?
Okay, let's see. With respect to Dr. Durrani and Cass, their behavior is governed by what the jury has found. And
She's talking about the settling party. How do we know what they settled for?
that would have to be with Randy Freaking with regard to Westchester Hospital and UC. He was the agent for dispersing the settlement amount, and he would have the numbers. And
But
I just want to represent one thing, if I may.
Sure, but let me just finish on
All
this
right.
theme really quickly, just so we can make sure that we understand.
Yes, ma'am.
So the source of the settlement with the other parties, the UC defendants
And Medtronic.
and Medtronic,
Yes, ma'am.
would be whatever settlement documents exist in those cases if we're looking at what they settled for, both in terms of amount and types of claims?
Well, the types of claims would be the complaint that was filed. In this case, it's readily seen. It's my client's complaint against Westchester UC and negligent credentialing, supervision, retention. I believe there is a Sales Act claim, fraud claim. Those are the types of claims that were extinguished by the settlement.
But isn't it possible that they pay out on, let's say, only negligence, and you release them on the rest?
We'd take the position that we release them all those claims against those hospitals, and punitive damages as well, I might add. But I don't think there is a breakdown that we just paid for negligence for Westchester UC Health. In fact, I would think that they would want a payment on all those things, so there's consideration for
Right, and
extinguishment of my
the
claim.
defendant doesn't care, right?
They don't care,
Like, they're
no.
just writing a check, they get the release that says everything, like, they're not concerned about allocation versus, negligence or intentional tort.
Right, I mean, I don't even think that was done, Judge.
Right.
I mean, as a mechanical thing, at the risk of stating the obvious, when there's a settlement, in comes the money to the administrator, he divvies it up, the net amount, and out it goes to the Durrani victims, less liens. One thing and in closing, I know of one instance where a settlement document was tendered to the judge. He said, produce it to defense counsel, and after the usual haggling how to deal with the internal controls, the document was produced. And I recall a document somewhere on the line signed by Michael Lyon that they're okay with the amount and go ahead and do what you're going to do. One instance, I can't remember which one it was. I asked that the verdict, the judgment of the trial court be affirmed with the exception of the settlement, and the amount is $87,400, a little bit south of that be reversed. Thank you.
Thank you. Mr. Herzog. You have 3 minutes.
Thank you, Your Honors. I would just say, in this particular case, the judge did, of course, grant a set-off because, and quoting Adams, said that you could distinguish between intentional and unintentional. So we do have a set-off and a set-off amount here. There are two issues that make this case a little different from some of the others you will hear. One is our argument over a mistrial, and the other is about Dr. Tayyeb's hearsay testimony that reinforces this notion that Dr. Durrani told people that their heads would fall off. I didn't get to address them in my merits argument, so mostly I wanted to raise them for you now in case you had particular questions.
Yeah, on the
about
mistrial issue, obviously he should not have been talking to the juror, but when that was brought to the court's attention, I believe that Mr. Stevens' counsel said, if you want to voir dire the juror, if you want to take these other measures, and defense counsel did not take him or the judge up on that. So how do we know that this was prejudicial beyond simply the fact that it happened? So
yes, trial counsel says to the judge, he moves orally for a mistrial.
Right.
The court says, that's pretty extreme here. And then you're right, the court does offer, do you want to voir dire him? And defense counsel at that point, knowing that the judge has said, I'm not going to grant a mistrial, moves on.
Yeah, but I think what he could have established is if there was some effect on that juror, maybe that juror gets excluded. And I think that's what we don't know by virtue of the decision, strategic or not, to not engage in those further measures.
I think the challenge is not a strategic one so much as a judge has effectively told you that the case is going to continue, has effectively denied the motion for mistrial from the outset, and on the ground that if only one juror is affected, maybe there's no mistrial. So I think trial counsel, understandably at that point, feels like they have to move on because the judge has made his ruling. Unless there are other questions on those topics, thank you for your time.
Thank you. Thank you both for your arguments on this case. The case is now submitted. And moving right along, we've got Hounshell versus Durrani. I believe that's Mr. Williamson. Do you want 3 minutes for rebuttal?
Yes, Your Honor.
Okay, and this is no cross appeal.
Onshore, right?
Hounshell, yes.
Thank you.
May it please the court, I am the same person I was when you heard from me about 45 minutes ago. I have not been replaced by a doppelganger. I do have for you a slightly different case, and that's Rita Hounshell. Again, I think some of the facts of how this case came to be are important and how you think about the strength of the case. Ms. Hounshell was injured more than 2 decades before she ever met Dr. Durrani. That's one day she was pregnant, vacuuming, carrying a baby, which is a lot to do at once, and injures her back. This is 1990. 1998, at work, she aggravates that injury. And as far as we know, from 1998 to 2012, she suffers without relief and suffers some pretty excruciating, extraordinary pain. She's suffering from osteoporosis and from thyroid disease, along with a number of other comorbidities, and then goes to see Dr. Durrani in August of 2012. We're 22 years into a pretty severe back injury. And he starts off recommending conservative care. Go to physical therapy, get a steroid injection. And Ms. Hounshell says no. She goes to 2 physical therapy appointments and says, hurts too much, I'm not going to do it. Gets 1 steroid injection, says, hurts too much, I'm not going to do it. And so Dr. Durrani then performs an L5-S1 fusion, it's lower back surgery. Ms. Hounshell then reports that she is satisfied with the surgery. We find, in the years following surgery, she does not go back to see another back physician until after she sues Dr. Durrani. When she goes to see that physician, Dr. Smale, in 2014, that doctor, who is not related to Dr. Durrani, is not affiliated with his practice, this patient comes to her and reports the pain is less than it was before surgery. That's in Dr. Smale's notes. Dr. Smale reports that the fusion seems to have gone just fine, and then recommends physical therapy to address Ms. Hounshell's residual pain. And again, Ms. Hounshell refuses to go. And somehow, out of all of that, the only cause of any injury here is supposedly Dr. Durrani's operation. That simply can't be true. And it turns out the jury seems to entertain some serious doubts about it, because you will see from the damages awards, particularly the future medical damages and the past pain and suffering, that the jury doesn't seem to think that Durrani did much, if anything, to injure Ms. Hounshell. So I think there are a couple of issues to address in this case. The first is that Dr. Durrani is entitled to judgment as a matter of law, we think, on the entire case, because he did not actually aggravate a pre-existing condition for Ms. Hounshell, which is to say the surgery didn't actually make her any worse off. And we think there are some discrete damages issues on which Dr. Durrani is entitled to judgment. As to the pre-existing conditions piece, it's undisputed that Dr. Durrani did not cause Ms. Hounshell's back problems. We have 22 years of that before she ever saw him.
Yeah, but I mean, that's going to be the same in most of these cases. Like, people are coming to him for a reason. They've got some condition, usually a chronic one, and so the question at trial becomes, well, is it a result of the prior condition, or was it aggravated or not by his surgery, right?
Exactly right, Your Honor, which is the point I was just about to get to, which is the question in this case then is, well, did he make her worse off? And you don't have much in the record to say that Ms. Hounshell was made worse off by the surgery, including going to see a physician after she had filed her first complaint in this action and reporting, I have less pain now than I did before he operated. This is not, to be clear, the records created about a month after surgery where Ms. Honchel says at trial, of course I said I was fine because I was on Percocet. We're now years post-surgery reporting to a physician, my back pain is less now in 2014 than it was
So
before I had surgery.
Bloomfield testifies, I believe, that that the surgery was unnecessary and that Durrani misled her into that surgery. So what do we do with that?
Well, Your Honor, there are a couple of things that I think you do with that. First is, one part of the negligence verdict is this claim that the surgery was itself negligently performed. So you have a breach of the standard of care as part of that negligence verdict. That part, Bloomfield's testimony does not sort of solve that problem, because what you have is a patient who is suffering 22 years of pain, has surgery, and then reports post-surgery, both in the month after and in years after, my pain is actually improved. And, Your Honor, given those facts, I think it actually becomes very difficult to believe Dr. Bloomfield's testimony that the surgery was unnecessary. The woman came to Dr. Durrani with a problem. Dr. Durrani solved that problem, and Dr. Bloomfield now testifies, well, that solution was unnecessary. Worth pointing out that of the three physicians whose testimony we're considering in that equation, Dr. Bloomfield is the only one who didn't see or treat Ms. Honchel.
And so did any expert testify for the plaintiff that the surgery caused or exacerbated her problems?
As I recall, Your Honor, I think Dr. Bloomfield does suggest that the surgeries made Ms. Honchel worse off. She reports at trial, which is is inconsistent with sort of her on-the-ground factual reporting during the surgeries, that sort of before surgery she's able to do a ton of sort of daily activities and now can't walk much. That's just flatly inconsistent with her medical records, really up until trial.
Yeah, but I mean, like, that happens not infrequently, that in both criminal and civil cases you have a witness change their stories a little bit, and here you have the benefit of her deposition and can cross-examine her and make her look bad from a credibility standpoint. So why doesn't that solve the problem, and why isn't it ultimately a jury question?
Well, Your Honor, it is ultimately a jury question, but it as I think I said in my first argument today, you still have to have a fair amount you have to have some competent, particularly expert testimony to establish your elements of medical tort, duty, breach, causation, damages.
So I mean, Bloomfield testifies that that this surgery was unnecessary, and it, at least in some measure, exacerbated her condition. And she's testifying now about like pain that she's got and so forth. So why is that not enough to get to the jury?
Your Honor, again, as a competent appellate attorney, I do have to stand here and tell you, if you want to write that opinion, you probably can, but you shouldn't. And in part because one of the core problems is you have sort of on one hand a treating physician who has, as even plaintiffs say at trial, no interest in the outcome of this case, telling you this woman is better, versus a physician who has a dog in this fight, who I think you have seen over the course of these cases sort of has a bone to pick with Dr. Durrani and has been hired specifically to, cast dirt on Dr. Durrani's performance here. Now, Your Honor, even if, and I suspect you are leaning, you decide that I don't win this point, it's worth keeping in your head that this is not an overwhelming evidence case. This is, in fact, at best for plaintiffs, a close case. Because again, 22 years of pain, surgery, and reported improvement, which makes some of the evidentiary errors committed in this case a little more egregious, including but not limited to the Durrani collage. But will you give me 1 minute before I switch to that on a couple of the judgment as a matter of law questions? One is past medical damages, which I think we've talked about a little bit today. I want to make one point about Robinson. Robinson is not a standing case, and it's not a real party and interest case. Robinson is about the very narrow question of, when you are measuring past medical damages, what's the measurement? Is the measurement the amount that someone actually paid, which, side note, I think should be the correct answer, or is it the amount that the hospital bills for the treatment? Robinson is not at all about who has standing to seek compensation for those damages, whatever they are. And on that question, who has standing to seek compensation, the Ohio Supreme Court has been absolutely clear. If the plaintiff does not pay, the plaintiff does not have standing.
And you're saying again, in this case, she had no out-of-pocket. There's nothing in the record to indicate that she had any out-of-pocket or that she was billed and owes money.
Correct, Your Honor.
Okay.
In fact, you will see in the trial court's order on past medical damages, sort of concession that, in fact, the insurance company is a real party in interest, but because the jury awarded more than the insurance companies actually paid out, the plaintiff gets to pocket the difference. The problem is the plaintiff never had standing to go to trial to seek any damage award in the first place. And so it's actually deeply unfair to the defendants to say, 2 years, 3 years, 4 years after you raised this problem, you're right. And our solution is not to give you what you asked for, which was exclude evidence of these past medical damages to begin with. Instead, you still get to pay the judgment, but we're going to hold part of it in escrow.
And I know I asked this before, but if she even had paid some co-pays, then you would say she would have standing?
I think we are in a different posture in that
Okay.
case, Your Honor.
All right. But
I might still fight with you a little bit on that
right,
one.
but this
I
is
don't-
really based on your argument that there's no evidence in the record that she paid anything out of pocket
Correct. Your Honor.
whatsoever.
And I have to highlight here that in these cases where we have raised this real party and interest question, plaintiffs are not coming back and saying, well, I had this out-of-pocket expense, so I have standing for the whole. Plaintiffs are coming back and saying, basically, that real party interest isn't a real problem to standing.
Counsel, I realize that this isn't what you're here for, but it seems to me that this is not only a problem for your client, but it's also a real due process problem for these insurers whose rights are being adjudicated in a proceeding that they might not even know is going on.
Correct, Your Honor. It is. There are a lot of good policy reasons for a rule like this, and the trial court sort of ignored nearly all of them. And again, I have to highlight here, it's the plaintiff's responsibility. So the last time we discussed real party and interest, which I think was in Setters 1 or Setters 2, there was some questioning about, well, why haven't defendants made an effort to join the insurers? And I confess I took a little umbrage at that question in the opinion. It's not the defendant's job to sort of go out and seek more plaintiffs to increase their own liability. Our job is to point out plaintiff does not have standing, and it is on the plaintiff to solve that problem.
There's been some suggestion, this is a case where Medicare is the real party and interest identified here, and there's been some suggestion that Medicare is maybe not suable. Can you speak to that?
My first impulse is that's not a problem for the defendants, it's a problem for the plaintiffs. But even if Medicare is not suable, there are a number of different ways that a plaintiff can sort of get standing or get permission from the insurer to prosecute the claim on the insurer's behalf, short of sort of joining them in a third-party complaint. Plaintiffs may choose any of those options, but you do have to pick one, and you do have to establish standing, and preferably you establish standing before you go to trial and before these damages are put in front of a jury, particularly when you have a defendant, as here, who objects to proceeding to trial on damages the plaintiff doesn't have standing to seek. And perhaps more succinctly, Your Honor, the fact that Medicare is not suable does not confer standing on the plaintiff to seek compensation for bills that the plaintiff didn't pay.
Would you agree, though, that the defense does have to raise the real party and interest argument? I mean, that's a defense, right?
It is a defense, and Your Honor, it has been raised in all of these cases.
You believe it's enough just to state it in the answer?
We do believe that it's enough just to state in the answer. I know that I am bound by setters, and so you will see in these cases, it's not just raised in the answer.
Right.
You will see pre- and post-trial motions relating to past medical damages. We have sort of taken the court's instruction seriously. And again, what I think is particularly frustrating in many of these cases is you have a trial court that agrees plaintiff is not the real party in interest to these damages. So the court is just going to sit on the money until insurance companies that, to Judge Kinsley's point, may or may not even be notified, decide to come and collect. And so what you have done is sort of created a solution for plaintiffs who, again, lack standing, and not one for defendants who have repeatedly tried to raise this issue, that during, you will notice again, and part of the reason why we are arguing 9 cases over the next 2 days, is you have instances of a trial court sitting on post-trial motions for years. These cases are 2019 trials, with trial court sitting on post-trial motions despite repeated encouragement from the defense counsel. Look, we have a real party and interest problem. We need you to resolve it. And basically holding those post-trial motions until plaintiffs can come up with a solution.
We have one, there's only one trial judge that's doing these cases, right?
Correct, Your Honor.
Okay.
I'm sympathetic to the difficulty of moving the trial calendar along under those circumstances. Even with that calendar, and particularly given the long stretch of time that we didn't have trials at all, 18 to 24 months feels like a long time to enter final judgments in 9 cases. Again, like during the pendency of those motions, defendants are coming back to the court and pointing out, it's been 6 months. Plaintiffs still have not resolved this problem. It's been a year since trial. Plaintiffs still have not resolved this problem. It's been 2 years since trial. Plaintiffs still have not resolved the problem. And the trial court says, essentially, I'll give them another 30 days and we'll see if they can come up with something. I fear my lights have long since gone off, and I didn't get a chance
We've
to get to
asked
the
you a lot of
evidentiary.
questions, so I'm not being a stickler, but you will reserve your 3 minutes.
Yeah.
Sure.
And I would say as to the evidentiary questions, happy to take those up in rebuttal. I think that maybe matter significantly in this case, unless you have
Yes.
questions now, but
Unless my colleagues have questions now. Okay.
thank you, Your Honors.
I'll say Mr. Williamson can do a good job at the trial court and arguing damages between the various doctors. But what got us to the jury and what the judge did not abuse his discretion in allowing Dr. Bloomfield to testify about was the future damages that I had it right here. Part had to do with this junction concept, that the unnecessary surgery will cause a weakening of the joint beneath the level of the surgery, which will require another surgery.
Are you talking about the future medical damages right now?
Yeah, I'm sorry. Did
And-
I start at a bad spot?
No, that's fine. I guess, was Wilkie the one that testified about that?
No, I have, at page 14 of my brief, 1415, Dr. Bloomfield testifies, it's just not possible to return Ms. Honchel to the condition she was prior to the unnecessary surgery. And he says that at volume 3, page 340. She will require medical care as approximate result of the unnecessary surgery. That's at page 341. At volume 3, the medical, there'll be non-surgical treatment required, such as emergency room visits, injections, physical therapy, and those.
Did he provide any kind of estimated cost of what that would be? I think that's what the problem is, right? I don't recall seeing that he estimated the cost of this future
Hold on,
treatment.
let me flip. Let's see, Ms. Hunts will require future medical care, volume 3, page 341. Talked about that. I'm not sure if this is the one.
I can tell you, I didn't see it, but if you have it somewhere.
Well, I have defense counsel saying that they agreed with what the jury did. At Volume 8, page 1277.
They agreed with the future damage award?
I submit to you, the jury, that the compensation that's always been awarded, that you guys had a well-thought-out decision. I think that's sufficient. And that's what
Well,
he's
counsel,
talking-
weren't they doing that in an effort to limit punitive
Then
damages?
That's right. But they said it. They didn't have to.
Isn't that just strategy?
They made a statement, Your Honor. Yes, they could have also said something else or said nothing. I mean, I wasn't in their shoes, I'm sorry, but they did say that they respected they said what they said. Dr. Bloomfield testified that she'll require future medical care. This is page 36 of my brief.
Right, he said she'd need future medical care, future pain management, but he didn't estimate what kind of expenses she would
I
incur.
didn't put that in my brief.
Okay.
If it was there, I'd have to look at the
Okay.
record.
All right.
Well, but I think the problem is if you've got experts saying like, she's going to need this care, she's going to need that care, and they don't affix a dollar amount to it, then doesn't that just encourage the jury to speculate on what the damages are?
It doesn't help. What they normally,
I mean, how's the
in
jury
other-
supposed to evaluate that? I
in other
guess?
cases, the doctors don't like to do that, Judge. So they'll say, well, just look at the past medical bills, and those will be an effective measure of
I mean, if
futures.
you're asking for damages, like you generally need an expert to testify what those damages are,
Yes,
even if
sir.
they don't like to do it.
It should be the doctors. I'm sorry, I didn't put that in the brief,
Yeah.
and I'd have to review Dr. Bloomfield's testimony.
So is Dr. Bloomfield the place that we should look?
Yes,
Okay.
yes. I think I made my point about Dr. Bloomfield testifies there will be futures. It's just we're trying to put a number on it. Just at my brief, we talk about past medicals and the plaintiff's entitlement to them. And I would just, you brought up Robinson. There are other cases following Robinson called Jacques Manton that adds to the concept that an injured plaintiff like Ms. Honchel would retain standing to recover past medical expenses in a medical negligence suit, even if they were paid in part or in full by an insurer who has a right of subrogation.
Did the trial court in this case, I know we're all struggling to keep them all straight. I know in some of the cases, the trial court made a finding that the insurers are the real party in interest. Did that happen in this case? Do you recall?
I'd have to go back to my desk and look,
Okay.
to tell you the truth. In the last case, he did.
Okay, let's assume that this is one where there was that finding. then what does that do to our calculation? If the trial court has said the insurance company is a real party in interest, how does that impact the plaintiff's standing, if at all?
There are three things. If it's Medicare and you have sovereign immunity and you can't sue them, I don't, of course, I don't have judicial power to bring in the Ohio Department of Medicaid. I don't know the precise name, but there's a case called Sauchel up of, it's not at Cuyahoga County, but Lake County, one of those counties.
But
up there.
is it really I don't know, is it really a suit against, I mean, she's not trying to recover damages from Medicare.
That Sauchel case is pretty clear, Judge. You can't join them in this case.
Well, then, so how is someone supposed to deal with this? I mean, do they just get to recover money as the plaintiff who's been the beneficiary of Medicare coverage, and Medicare just gets?
Somebody negotiated with them on this broad thing with regard to Durrani victims' Medicare payments. They all got settled. And I didn't participate.
Well, but I think that gets to like some of what the defense counsel is raising here, which is like, maybe there was this mechanism, but how do we know that then allowed your plaintiff to have standing to recover these past medical damages? What was the settlement mechanism in that would have either waived Medicare's right to subrogation or made some measure for
My
it?
recollection is that there was a hearing November-ish of, anyway, there was a hearing. The defense counsel brought up the fact that Medicaid had settled, and they agreed that a settlement had been reached, and all that money had been addressed. How, I'm not sure. But then the trial judge said, okay, that's now moot. Whatever is available and tied up by the Medicare lien is now released to the Durrani victim plaintiff. And I could get a couple of those cases that where Judge Reese has ruled that way. I don't know if it's-
Is that settlement agreement with Medicare, is that in the record anywhere? Or?
It would be in, it wouldn't be in the decision deciding the JNOV motion. It would be in the final decisions just prior to the final judgment. You'll see it there, just before the final
Okay.
judgment.
Right, thank you.
That's my recollection. And let's see, I had a really great point, and I forgot what it was. There were three things. I got two of them down. I forgot. I'm so sorry. Just one point, talk about length of trial. I mean, the plaintiffs were here once before. We withdrew our motion to withdraw prejudgment interest and attorney's fees, hoping to generate a final judgment. And on three of the cases.
Let me ask you about that.
Yeah.
I understand kind of in the landscape of this,
Yes, ma'am.
as the newcomer here, I understand.
It's always the first time for everything.
Looking backwards at what's been going on, I can see where that might have happened. But why would your clients want to enable an appeal in cases that you prevailed on?
We just want to get it, they're going to appeal. You can bet the deed to the ranch, Judge. So let's just get
Show
started
on the
and
road.
get it done.
All right.
That's right.
Thank you.
And as a point, this honorable court ruled in every one of them that the effort to accelerate was null, and came back and said, make a decision. And we made a decision, those should be law of the case to all these cases. Let's just be done with it and get PJ, a prejudgment interest decided and move on to where we are now.
In the absence of the orders from this court in the McCann case and the Potts case, I think those were the two that it came out in, would your clients have withdrawn those motions, or were you doing that just based on reliance?
We're just trying to accelerate the situation. I think there was a Mittendorf case too.
Mittendorf, okay.
I believe there are 3 of them that came this way. But those were designed to, those ended all the post-judgment motions at the trial court and
So you're-
leaving a final appealable order.
So your client was willing to forego prejudgment interest,
Just to get here, yes.
just to get here? Okay.
And you said, the court, not you, Judge Krause, but this court said that cannot be done. That's and sent it back to the trial court for further ruling. But all I'm saying is that, plaintiffs has some frustration over the length of trial and getting a decision too. So Dr. Durrani and Cass are not the Lone Rangers on that point. We didn't have anything dealing with a cross-claim here, so I would ask that the judgment of the trial court be affirmed in its entirety.
Thank you. Mr. Williamson?
Your Honors, I will again attempt to be fairly brief here, but launch into some of the evidentiary issues pertaining that this was a close case. The Durrani collage came into this case. Despite much of what you have heard today about the purpose of the collage, counsel was pretty transparent, particularly in this case, that the collage was about impeaching Dr. Durrani's credibility. That was the point of the collage, was impeachment evidence. You see it in closing argument when plaintiff's counsel says, look, this case really comes down to credibility.
Counsel, let me ask you about that.
Yeah.
So not a lot in this collage is actually impeaching. I found one instance where Dr. Durrani makes an admission of something that maybe wasn't true. That he was asked a question about referencing a position like director of spine surgery or something like that at one of the hospitals, and he does admit that that was not a position that existed at the time. He was like their lead guy, I think is what he says, but that director position didn't exist. But other than that, from my review, all of the times he is asked about an alleged falsification or an alleged untruth or an alleged denied disclosure, he says he either doesn't remember or he didn't do it. So how does the collage actually show falsification or lack of truthfulness?
Well, Your Honor, therein lies part of the problem. It doesn't. So the collage itself is not particularly useful, or at least it shouldn't be on paper for the purpose that plaintiffs wanted to introduce it. The problem is that you play the collage video and then plaintiff's counsel stands up to tell the court or tell the jury, and you see throughout this collage that Dr. Durrani lied about all of these things. That's the representation you get in closing argument is, you saw the tape, you saw the testimony, you saw how he behaves, and he can't tell the truth. So perhaps on paper, you might argue the Durrani collage at least shouldn't be impeaching, but then when you have counsel say, and by the way, everything that you just watched was false, we have a serious problem.
Doesn't that cross over into the attorneys starting to testify then? Because we don't have in our record his actual CV, his actual resume, this allegedly false Scottish Rite research from the 1990s, the biographies pulled off the internet that have false accolades in them. We don't have any of this information in front of us, so how do we know that it's false?
Your Honor, that is part of our point. We have a collage introduced to impeach a guy who's not testifying. We don't have much here to test counsel's assertion that Dr. Durrani has fabricated things. It probably does cross impermissibly into counsel testifying. And these are problems that are created and exacerbated by the trial court allowing this collage to be played in the first place.
Can I just ask you, so if this had been done properly, if there had been, I mean, we're having some issues with how this impeaching information came in. Now, if the purpose was to impeach his credibility, and the questions had been asked properly, this information that Judge Kinsley talked about had been laid before him, and he had admitted to it and saw it and said, yes, I left this off my application, or yes, you're right, this was based on fraudulent research or whatever. Would that then have been proper, even though it wasn't specific to this case, but it was maybe like a chunk of a cross-examination for another case? Would that have been a proper thing to put in?
Well, so that might be true as to some questions. You can examine a witness on sort of basic questions about your resume and you know what makes you an expert.
Lying on your resume or whatever.
This collage gets into questions that could not have been asked or raised fairly, even if Dr. Durrani had admitted that he was a liar. You're not supposed to ask a witness about whether you have other medical malpractice actions. That's sort of classic.
Well, what about if they asked him, weren't you supposed to disclose pending medical malpractice cases on your sworn application?
So,
And he says, yes. Did you? No. Or did you? Or I didn't have any or something. I mean, could they then bring in the medical malpractice cases to impeach him?
I think, Your Honor, you would still find us objecting on grounds it's impermissible other acts evidence.
Okay.
As we raised in the trial court, there's a problem with sort of bringing into the case records that should be confidential parts of a state medical board investigation, which we litigated pretty thoroughly in the trial court. There are a number of reasons why that question still doesn't come in.
Okay.
But I can't emphasize enough, that's not the context in which it came in this case.
Counsel, from my perspective, I think everything in the collage has to go through a three-step inquiry, starting with relevance and then moving to admissibility and then looking at the 404 weighing. Did that happen at all in this case?
As far as I know, no. You see some cutting down of the Durrani collage. It started as 16 hours of pieces of depositions from other cases. I have to point out, none of those cases were Ms. Hounshell's case.
And none of them were trial depots, right? They were discovery depots, or?
It appears they were mostly discovery depots. Part of the problem we have here, Your Honor, is plaintiff's counsel is the one that stitched this together. Mm-hmm. What you have is not 16 hours worth of deposition transcripts went to the trial court, and the trial court said, this is the hour and a half or 50 minutes you get to use. What happened is plaintiff's counsel said, this is the 80 minutes of questions that we really want to put in front of the jury because it'll really show Durrani looking bad. You have that in closing arguments in some of these cases. And then the trial court saying, okay, some of these things really are, more out of bounds than others. There is, I think, some question about sort of the contents of the collage. I just want to point out, in Hounshell, you actually have the trial court describing what is in the video, and it is this, did you lie about treating the Saudi royal family? I can't imagine a case in which that's relevant. Questions about the family textile business in Pakistan. Again, what does that have to do with the facts in this case? So that's TD 198. It's the September 28, 2021 order. Where you on page 3, the trial court describes the contents of the collage and then just says, and this was fine. While you are reading TD 198, I think Judge Kinsley, you may have asked the question of Mr. Winter, did the trial court find here that the insurers were the real party in interest. In fact, the trial court did. You also find that on page 3 at TD 198. It's the September 28th order. And one sort of recurring frustration, Mr. Winter points out, there's this sort of global settlement with Medicare that comes in, I believe the hearing was July of 2021. That's 2 years after the trial in this case. You can't fix standing 2 years post-trial. That's just not how we litigate cases.
Is that when the trial court found that the insurer was the real party in interest? After the trial?
Yes, Your Honor. Because the trial court basically refused to issue a ruling on that question during the multiple instances that defense counsel raises this problem. And we were not delinquent, particularly in the post-trial motions, in pushing that question. It's in the first post-trial motion, less than a month after trial, and the trial court sort of continues to refuse to resolve that problem while giving the plaintiff more and more time to sort of come up with a solution to their real party and interest problem. I think, as we maybe have pointed out elsewhere, the fact that the insurer has sovereign immunity and can't be sued doesn't mean the plaintiff has standing. And among other things, you can go to Medicare and ask for the right to sue, which again is a thing that.
Well, there's an administrative framework too.
And none of that happened in this case, and it didn't happen before trial. On the trial counsel concession on future medical damages, I think Judge Kinsley, you rightly pointed out, and we addressed this in our brief, this is after we've moved from the liability phase and into punitive damages. It's trial counsel trying to point out to the jury, look, you don't need to award punitive damages in this case. This was not a concession that the damage award was itself, right and just. And I think Judge Bergeron, you may have raised the question, Judge Krause raised the question, what do we do when you have an expert that testifies that future medical care will be necessary but doesn't give a dollar amount? What you do in that case is you apply Setters 1 and Waller and Hammerschmidt, which say if you don't have a dollar figure, you leave the jury speculating and you don't get damages. And in this case, even the course of treatment that Dr. Bloomfield testifies to, and Judge Krause, you're right, he doesn't give a dollar figure, but the course of treatment he testifies to includes physical therapy and steroid injections. You said in Setters 1, those future medical damages have to be reasonably certain to occur. The demonstrated history of Ms. Townshall is physical therapy and steroid injections is not a course of treatment that she is willing to follow. So it seems to me very difficult to conclude she is reasonably certain to incur future medical expenses for physical therapy and steroid injections.
And you are way behind.
I'm way over my time, and so I think to the rest of the issues we'll stand on our briefs.
We've got more.
Court has questions.
Okay, great.
You were done with me today, and I will see you bright and early in the morning.
All right, thank you so much. All right, so the Hounshall case is submitted. We have one final case for argument today, and that is Mann versus Durrani. This is another cross appeal. Mr. Herzig, 3 minutes?
3 minutes, Your Honor.
And Mr. Winter, do you want to reserve?
I'll try hard to reserve
You
my
do?
2 minutes.
Okay. Can do whatever you want. All right, thank you.
Mr. Herzig, I'd like to just cut to the chase in this case. Help us understand how there's a final appealable order here, because when we look at the record, Humana intervened and filed a complaint, and it doesn't appear that there are any entries disposing of that complaint. So Humana appears to be hanging out at the trial court level. How do we have jurisdiction?
Thank you to the court for flagging that issue. What we can tell from the record is that relying on a statement from Humana's counsel that it would give Ms. Mann the right to sue on its behalf, the court allowed it to intervene, and Nunc Pro Tunc put its complaint on the docket. And you're right, the next thing we hear about them is in the post-trial decisions in which the court says Humana's, that kind of recounts all of that and then says the case is over. It is I guess one could argue, if one wanted to, that the final appealable order in fact disposed of their case. Our challenge would be, as we've seen in these other cases, that we don't have any underlying evidence to know, other than a statement by the attorneys for Humana, that the case actually.
Well, I guess that's where I wanted to go, which is if Humana gave the plaintiff the right to sue on its behalf, then presumably that moots out Humana's interest, and then it's just a whatever the arrangement was between them. But you're saying our only evidence of that is a statement. Is it on the record, or is it just your understanding?
Well, the trial court puts on the record in its order granting the motion to intervene. It says it says on April, this is a September 14, 2021 entry. On April 30th, 2021, a hearing was held in this court at which time, at which time Humana stated, we'll file a motion to intervene as plaintiffs, and when that is granted, a motion will be filed dismissing Humana as a party as it is transferred or assigned their subrogation interests to plaintiff. So that's what we know about the assignment of the right to sue.
But that didn't
never
happen.
happened. Correct.
Right, okay.
Yes. So does the final judgment entry, the parties then proceeded along those lines. There's a final judgment entry that ends the case, and I think intends to end the case as to Humana 2. Is that sufficient for jurisdiction? It's a close. Candidly, I'm not sure, and I'm open to answering more questions about it. I apologize that I don't have a better answer than that, other than to say I don't know that there's anything more to do. Right? That's kind of the question you ultimately ask: is does a final judgment leave anything else to do? And the answer here is no. I guess one could say, well, we should have an order either dismissing Humana or formalizing more the subrogation right or the assigned right to sue. But I think there's nothing more to do here, and so I would say you do have jurisdiction, and I don't think it's a point that we intend to challenge. In terms of the court's jurisdiction, we're comfortable.
On that point, one additional question. So the representation comes from counsel that Humana has assigned its interest to the plaintiffs. Nothing is ever filed, right? We don't have anything in the record to confirm that?
And that is our concern, yes. I think that's right. But that gets to, for us, that gets back to an evidentiary, really the evidentiary question as to whether there is, what is the set-off amount, what is the interest that was subrogated, all those things. We don't have any record of that.
And from a due process standpoint, that is a document that you would like to see?
Yes. Other questions on the jurisdictional issue that you raised? Other than that, the Mann case has most of the other errors that we have raised in these various appeals. And I guess I would go back to the collage for a minute. The challenge with whether it was used for impeachment or not, whether that was the intention or not, the real point of it is to have the attorney's questions come in about license revocations, about other medical malpractice cases, about potential criminal complaints that were made and then dismissed, about where he is and why he is there. None of which is, as to Judge Kinsley's point, is relevant in the first instance. It is not admissible as to any of these particular plaintiffs, and even if it were, as you've already determined for many of these errors and setters, one, it is unfairly prejudicial and should never have come in.
But you're not arguing that if this were a proper impeachment done properly, even though it was done in a different depot, that they couldn't have put this piece of it in this trial? It was done for a different case. So it was just the impeachment piece I guess allegedly to show his credibility. And I understand all your issues with the collage, but if it had been done in a proper manner, could they have just snipped that out of a different proceeding and
So,
put it in this one?
so certainly sworn testimony can be admissible.
Right, statement by party opponent.
Right. You know, you could find ways to get it in, but that's not really what, you'd have to take out all the problematic stuff.
Your issue is not that the fact that this testimony came from a deposition on a different case. It's about the content of what was put in front of the jury.
Yes, as to
Yeah.
some of the testimony. I think it is important to note that the stuff that you should be asking a physician about in a medical malpractice case is his treatment of that particular patient, the decisions that were made, you know, why
Well, can't
why
they
this
ask him
procedure.
general questions? I mean, for example, I noticed there's one question about whether Dr. Durrani reads his own MRIs in addition to relying upon the radiologist's recommendation. And he gives a substantive response to that question. Why is that not admissible?
I don't think we're arguing that something like that wouldn't be admissible, and you're right, a sworn testimony in one case, if it could be applied throughout all cases. If the question is asked right, is it true that in no case you look at the MRI and he says yes, then you could have that testimony come in across lots of cases. The problem is, when's the last time you beat your wife, sir? That question doesn't get to come in at trial because the question itself is prejudicial.
So do you agree then that we have to go question by question and look at each piece of the collage?
So, I think our problem with the collage is that we think the entire purpose of it is to create unfair prejudice. But yes, if the court wanted to go through piece by piece and cut out all of the specific things that we have objected to, the medical license revocations, the other medical malpractice cases, all of those irrelevant things about criminal complaints or whether or not he has a license any longer, none of which are even relevant, let alone admissible or not unfairly prejudicial. If you wanted to cut all those things out, you could use pieces of this testimony. No one has ever attempted, plaintiffs have never been pushed to do that by the trial court. The trial court lets the whole thing in. They then have a trial where the allegations about medical license revocation continue throughout the case. The allegations about other medical malpractice, they try to bleed that into the case throughout, and the judge lets it all continue.
Can I ask you on the criminal issue, which I question, once you guys get this straightened out, what actually the jury heard, because like I said, that piece I didn't see on the video that we saw, but I thought the criminal question was asked in relation to some sworn application that he submitted where he was asked about pending criminal charges and he left it blank. Right? So wasn't the question asked in relation to that he lied on an application?
I think that's correct, Your Honor. How is that relevant to whether he committed the acts in the complaint against Miss Mann or any other plaintiff here in this case?
Doesn't that go to his credibility of what, I thought that the plaintiffs are arguing that he said to have a surgery that was not supported by the records, and he lied about that. So doesn't that go toward his credibility, that he left off something off of a sworn application?
No, Your Honor, I don't think you would let that in a case like this. I think Judge Bergeron points out earlier that you have the records you have his actual medical records in this case. You have experts who say, experts for and against, who say, the plaintiff's experts say, well, this isn't true, I don't see this, that's not the case. And that's where you can impeach him as to his medical
And so if
judgment
Durrani
and the
had
like.
said in this video, here's what I intended here, this is what I meant, and then you're able to impeach him on that, that's fair game, right?
Yes, Your Honor. I mean,
Yeah.
we're not saying he's not subject to cross-examination.
I mean,
or
just
anything
to
like
make
that.
sure I understand it, it sounds like what you're saying is part of the issue in a 403 balancing is the probative value of all this, according to you, is minimal. The prejudicial value is high, so that's how the scales tip. And if the probative value were increased, that would impact the balancing under 403.
Yes, Your Honor.
So any questioning on leaving off important information off a sworn application, you're saying would not be relevant to determining whether he committed malpractice?
In this particular case, I think one thing the court has done very well throughout these today, and I'm sure will tomorrow, you have looked specifically at each case, which is a difficult thing to untangle and undo. That's what has to happen at the trial court level, too. What is it about this, what testimony in that collage, let's say, or any other testimony matters as to this plaintiff? And no, I don't think that would be relevant. I certainly don't think that the probative value would outweigh the unfair prejudice, which is
And let me ask
quite
you
high.
specifically about the questions related to Pakistan, that, that's where you live, that's where you are right now, that's where you went to medical school. Help me understand how that is prejudicial at the end of the day.
Well, I think if that's all that there was, it might not be. What you have, though, is, and you can see it throughout opening and closing arguments across all of these cases, is an effort to try to use that as a sword to hope that it does create prejudice. And so I think simply asking somebody where they are is not necessarily prejudicial in and of itself, but certainly doing it to drive home the point of where someone happens to be from is very problematic in our judicial system, and one that I don't think the court countenances.
You are at your time if you want to reserve 3 minutes.
I will, thank you.
Okay, thank you. Mr. Warner?
Bob Byrne on behalf of Tammy Mann. With regard to the jurisdictional matter that we've raised, I join with my colleague. I'm not sure how that shakes out as to whether the court has jurisdiction. I haven't done the research that's needed to do it. It's an unusual case, but I would think that the court would have jurisdiction over what's before the court now, not on what's in escrow and what
Counsel, in some of the other cases, the
Yes, ma'am.
trial court has severed off some of these insurance pieces.
Yes,
That did not happen with Humana here in this case, right?
I believe that in every other case where there's an escrow, the amount of the judgment's been decreased, the economic damages. I looked at,
I think this is the only one, I think,
I didn't check.
where,
Truthful.
where an insurer actually intervened and filed a complaint. And I don't think the trial court severed that off in the way that it has
Everybody else.
escrowed it. Yeah, this one seems to be just differently postured, and that Humana piece has not been, at least directly, expressly resolved, because that complaint is still there.
I did not check that. I didn't check the math, Your Honor, to be truthful. I don't know. If I can move on just very briefly to the collage. I was there when they took that deposition. It went on and on and on. It's the only time where plaintiff's counsel were allowed to depose Durrani. It was a discovery deposition. It wasn't a trial deposition.
So the collage is cut from a single deposition?
Yes. Well, there may be two. I take
there's
that back.
two.
There may be two, yes. But we've been assured, subject to further discussion, that there will not be any other depositions of Dr. Ronnie. This is the only time where a jury will have the opportunity to,
Yeah, but I mean, that's not a justification for playing
Right.
it. I mean, if he chooses not to show up, then he's an empty chair there, and they can all perceive that.
but we have something, Judge, and we think that the jury should be able to see him, see how he answers questions.
Right, but I guess this gets back to my concern about, is this impeachment? Like, normally, someone testifies as to something inconsistently, and then you impeach him. In this case, that's not really happening, as I understand it. You're showing this video that's got the greatest hits of everything that, you don't like him saying, that you want the jury to see. But that, to me, doesn't really seem like it's being offered for impeachment purposes.
I mean,
Why-
Judge Kingsley brought up one point. There's another point where, he says he went on his applications, he went to A college, but he actually went to C college. This deposition has gone through an awful lot of editing. Dr. Sonneman viewed it twice that I'm aware of. Judge Reese looked at it, and his predecessor, and I can't think of his name.
Schweiker.
That's right. Thank you. There's been a lot of editing, as you can tell. I'm not sure, it's not in this record of what was edited out that might have provided answers. But we certainly, the point is that it's his habit to answer questions under oath falsely.
How does this deposition show that, though? We don't have any of the proof that these answers are false. I mean, we can assume it. I don't doubt that the attorneys who are asking these questions have a good faith basis for asking them. But how do we know that these answers are not true?
The best I can tell you now, and I'm not positive, but they've been edited out. Some have been edited out, if not most, if not all.
Why?
Judges do make decisions, Your Honor.
But a lot of these questions, he says that he's not sure or he doesn't remember.
Right.
Yeah.
And so I
Right.
think the concern is that, like, he says something like that. You ask him this loaded question about, like, you did something nefarious, didn't you? And he's like, I don't know what you're talking about. And then in closing, trial counsel comes back. It's like, he lied. And I think what the questions that we're getting at are, but where's the substantiation of that? And like, if you're presenting this as proof that he's lying about something, then it should show that he's lying, and it should be relevant to the proceedings that we're talking about.
Well, I don't know if, for example, the CV got faxed over as soon as the question was answered, and then further diatribe was had or not.
All we know is what the jury saw, though, right? So. I mean,
Correct, yes.
Yeah, so.
That's it.
But that's the thing. I mean, it just, that's what we're harping on. We're going on the fact that the lawyer is basically testifying, and in many instances, Dr. Durrani says, I don't remember, or I don't know. And then it's argued that he's lying.
And in at least two, if not more instances, he was under.
But let's assume that's true. Let's assume Durrani lied every day, and you've caught him in this web of lies.
I'll stipulate his qualifications. Your Honor.
But how is that probative of this case and this plaintiff and the procedure that was done in this case? Like, what is the value of establishing that he was a liar? How does that?
Dr. Wilkie, well, not necessarily Wilkie in this case, but Ciani, Bloomfield, Wilkie.
But they are specific about his statements to the plaintiff, and that he was inaccurate in prescribing this course of treatment or in making this representation. And that's why we upheld Wilkie's statements in the prior case.
Right.
But this is totally independent of that. It's just like, I'm lying about what day of the week it is or what the color of the car is. Like, I'm lying about stuff. Like, how does that?
In this case, it's just not garden variety lying, it's lying under oath. That's special,
okay,
that's special to me anyway.
But like, he wasn't testifying under oath other than in this collage. So like, I'm still having trouble understanding the evidentiary basis. If you've got evidence of this guy lying, but it's not about this case, then what is the evidentiary basis to get that in front of the jury?
It's lying about his medical applications or renewals of it. It's dear to his heart, or it ought to be. And he says stuff, he says that his applications were sworn to under oath. And then he goes ahead and says, there are 2 instances where I made a false statement. And then, some third party filled it in for me, and I just went ahead and signed it in front of him. If that's his practice or habit of dealing with these type of important things,
But then you're asking the jury to find him liable based on propensity inference.
I'm sorry, sir.
On the propensity inference, that because he does it in other contexts, he must be doing it here. Right?
That's his practice and procedure of dealing with important, on the record, under oath in his chosen profession. He's going to make statements in his chosen profession as to Ms. Mann and all the.
So, I mean, just to be clear, what you're saying is because he lied elsewhere, that means he lied to Ms. Mann here.
He has the wherewithal to do that. He knows how to do it. There are a couple of sentences I reviewed where he was right, and that's for my colleagues to sort out in closing argument. But he certainly has, the gumption, the wherewithal, the habit, professional practice to lie under oath on matters that are fundamental to his chosen profession. It's the best I can do, Judge.
All right, no, thank you.
Do I have I don't think I had a cross-claim here.
You did have a cross-claim.
Okay,
You reserved 2 minutes for it, though.
Okay,
You want to
well-
do a rebuttal?
Yeah, let me have a couple minutes of rebuttal. Thanks.
Well, you've got actually 4 minutes for rebuttal, so there you go. I'll save your time.
Thank you.
Okay.
Your Honor, I was going to waive the remainder of my time unless you would like to let him address the particular cross appeal, and then I could maybe respond to that for a minute or two.
No, I get the end of the cross.
Yeah, he wants the end of the cross appeal. If you want to, do you want 3 minutes?
Sure.
Okay.
I don't think there's much more to say that we haven't covered in the other cases, so I guess I would say unless you have particular questions about it, this is another case where the court did find a set-off, meaning that it did sort between the intentional and the unintentional torts, so set-off is appropriate. The problem, of course, though, is that we don't
Remind
actually
me,
have
how did the court differentiate between the intentional and unintentional?
It made a finding in its decision, its post-judgment decision finds between those two things.
And specifically, I just had it, but I just closed my laptop. Specifically, what was the finding by?
I apologize if I tricked Your Honor into closing his laptop. There isn't much specificity in the order. It's simply, but it is an order dividing.
Well, I guess that's
Dividing
what I'm getting at. Like, how, if it's not distinguished on the verdict form, how does a judge, after the fact, make some conclusion as to what percentage was intentional versus not?
I think it's part of the difficulty with the evidentiary record we have on these cases, including the fact that we don't have the actual agreements between any of the settling parties or the subrogating parties as to what they as to what they actually found. I am, and I apologize, I don't have the jury verdict form in front of me to remember whether the jury specifically split the amounts out here. I would also note, Judge Kinsley, to your point, that this case does end up holding in escrow the Anthem amount, but not the Humana amount. So your recollection, I think, is correct on that. Unless there are other questions.
I do have a
Yes.
question actually on the set-off issue. I noticed that in some of your briefing, I think maybe it was in your reply, that you intimated that there was perhaps a jury instruction request to apportion. Where specifically was that, and why did the trial court deny that request?
So there, it's been made more explicit in more recent trials, but we did ask, we had interrogatories that would have broken those things out, and they were rejected. I don't think there was much statement as to why.
So it's unexplained.
Yes, Your Honor. Thank you.
Thank you. Mr. Winter, you have 4 minutes left.
The jury found for Ms. Mann on her negligent lack of informed consent and fraudulent misrepresentation of the necessity of the surgery. And under Adams, you just can't possibly pull out which, you know.
Because the verdict form doesn't distinguish between, like, you found X dollars for fraud and
Right.
Y dollars for.
Yeah, I've seen one case where that happened, but this isn't it.
Right.
So, you know, an intentional tortfeasor is not entitled to a set-off. That's what Adams said. That's what that other case, I think it's in the 8th District, Johnson. It's an intentional tort case. You don't get a set-off. So consequently, I ask that it was $89,000-ish. I would ask that the court affirm the judgment of the trial court, except reverse the set-off. And I thank you for your time.
Do we know, one final question, counsel.
Sure.
Do we know why some of these cases are going your way on the set-off issue and some of them are going Durrani's way? Is there any way to distinguish
Well,
these?
anything
or-
going their way is wrong. How's that?
Fair enough.
I know the one where they got the information and then we stipulated that everything was in a certain form, and I'm not sure where that case is in the process right now.
Is it a time issue? Like, were the earlier ones going one way and the later ones were going a different way? Has something changed? Is there something unique about the cases that result in set-off? Are they haphazard? Can you help me categorize these?
The answer is, try me again, okay? Please, Your Honor.
Is there some way to categorize these set-off cases? Like, do the earlier ones go your way? Do the later ones go your way? Are they just all over the place? Like, is there some way to look at these and make them make sense?
Well, I take the position that whenever he's liable for an intentional tort, there's no set-off. Before Adams, that argument was a loser. The more recent cases where the trial judge recognizes Adams, they've been going my way. I think that's the best I can do.
So Adams changed the game, basically?
Yes, ma'am.
All right, thank you. That helps me. Thank you.
Thank you, judges.
Thank you. Thank you all for your arguments today. This case is submitted. We have 5 more on tomorrow, so another marathon day. Look forward to seeing everybody. Have a good rest of your day.